Hi, I'm Chris Colvin. I'm the founder of In the House. Our mission is to empower in-house attorneys by providing educational, thought leadership, and professional networking opportunities. One of the ways we do that is through our monthly working groups, which we have on various topics. We meet on this day each month in our manufacturing sector working group. The co-chair of our working group is Kathy Perales. She's the general counsel of PMI PMI Oil Tools, excuse me, as well as being the co-chair of In the House's manufacturing sector working group. So Kathy, I'll just pass the mic to you, and if you'd please introduce our guest today and our topic.
All right. Thank you. Today we have three veteran intellectual property attorneys. Each of them is going to serve as an expert for one country here in North America. I'm going to introduce them in the order they're appearing on my screen. Arash Baravesh is with the law firm of Manava and King in Washington, D.C., and he's going to be talking about the U.S. Daphne Laneson. She's been with the law firm of Smart and Bigger in Ottawa, Canada for her entire career. She's going to talk about Canadian laws. And Viviana Agudelo, she's worked in both law firms and in-house at PepsiCo in Mexico City. Now she's with the law firm of Olarte Mure, I hope I said that right, in Bogota, Colombia. So thank you so much for being here. And we're not necessarily intending to lay out the basics of patent or trademark law. Today we're talking about the differences, important things that our experts think that you should know when you're thinking about whether to protect your intellectual property in the three biggest countries in North America. So please feel free to ask questions, as Chris has said. We'll try to look at the chat box in case you just want to type them in. And I may rein in the questions if we get a lot, because there's a whole lot to cover today. So we thought we would just start with copyright law. Arash, would you like to get us started?
Sure, absolutely. Chris, if you could bring my slides up, that would be great. So one thing that we're going to talk about today is copyrights and trademarks, and also patents and trade secrets. Those are the three areas that we're going to cover. So the first thing about copyright is that it protects the rights of authors and the original work, meaning that if it's novel, painting, films, songs, and now it also relates to business-related works such as software and so forth. So when you file a copyright, there's no requirement for you to register it with the Copyright Office in the United States. Once you put something on paper, it's automatically considered to be copyrighted. However, if you find somebody who is infringing it, then you do need to file the copyright, have a registered copyright. And recently, a case came out where it said that you actually need to have the registration in hand and not just have it pending. Once you file the copyright, so there are two ways to go about it. One of them, the author can be anonymous, or the author can have his name or her name shown. If the author has his or her name shown, then the length of the copyright is roughly 70 years plus the lifetime of the author. Now, if it's pseudo-anonymous, or an anonymous author, then the copyright term is 95 years, or also from the first year of its publication, or the term of 120 years from the year that it was first created. When you file the application, you have to write when the work was created and when it was published, so they can calculate it from those days. So let's assume for a second that you have a registered copyright, and you notice that somebody has copied the work of art or your drawings and so forth. And the engineering drawings can also be copyrighted. So what are the remedies for it? So in the United States, we can have several different ways of going about it. One of them is the actual damages that resulted from the person or the company infringing and copying the copyrighted material. The second one is the statutory damages. And in the US, the minimum statutory damages, I believe, is $750 per copyright, and up to $15,000, depending on I guess if the infringer actually knew about it and also intentionally copied the material. Obviously, it would be the $15,000 versus the $750. Another thing that you can do is injunctive relief, which doesn't involve any money. You just make them stop producing your work. And you can also have the copyrighted material that was copied seized and destroyed. And one thing about copyright is that the courts are fairly lenient about giving the attorney fees back if they're reasonable. I know I went pretty quickly through this.
Daphne, you ready to talk about Canada?
Yes. So, Chris, I think the first slide in my deck. So while Chris is pulling it up, I'll just start. I think really one of the major differences between Canada and the US right now is the term of protection. So we are still under the life of the author plus 50 years. However, if the US-Mexico-Canada agreement or the new NAFTA ever comes into effect, we will be required to extend our term to 70 years. So then we'll be consistent with the US. But right now it's just life of author plus 50. As in the US, registration is not a requirement, but registration does provide you with the benefit in terms of enforcing your rights. We also have a very robust remedial relief system in Canada. There are a number of equitable remedies like injunction, as well as damages, including statutory damages, as you have in the US. And there are other remedies like a civil search warrant that are routinely used in copyright cases and are unlikely available in many other instances. For the most part, we had not seen very much copyright litigation in Canada until the last few years, where there actually has been an uptick, for example, dealing with videos and distribution of videos via set-top boxes or the like. So this is something that I think copyright law had been, I'm going to say, somewhat dormant for a period of time, but it is receiving a bit of a renaissance with the expansion in terms of how media is being deployed, and in view of the robust remedial relief, we are seeing people start to assert their rights.
I have a quick question. Can you have it as anonymous, or does the author needs to put their name on the registration?
That's a good question. I can't recall offhand exactly what the form says. I believe you have to identify the author.
Okay.
Yeah.
All right, Viviana, you ready to tell us about Mexico?
Yes, thank you. If you could pull up my slide, please.
Just a minute. So let me just
Thank you.
give me a second to pull up the share. There we go. Okay.
Okay, thank you. So copyright protection in Mexico derives from the Constitution there, from Article 28. And it pretty much follows the same, many things of the US and Canada. However, because Mexico is a civil law country, which means that decisions from the courts are not necessarily followed as law in all cases. They have statutes. They have adopted also the Berne Convention, and the Berne Convention is one of the treaties that applies for copyright. The National Copyright Institute as the public copyright registry. Therefore, you have to register your work with that office. However, you do not get protection in Mexico with the registration. You get protection from the moment of creation, and basically, and more specifically, from the moment that it's fixated in a tangible medium of expression, which is similar to the United States. In the Berne Convention for the protection of artistic and literary works applies in Mexico, like I said before, and one of the particular aspects of the Berne Convention is that it recognizes it divides or separates moral rights from economic rights. So moral rights are those rights of authorship that cannot be assigned to anyone, and they are perpetual rights that will remain in the head owned by the author. The economic rights are those that can be exploited, and they can be assigned or can be manipulated in order to get some retribution for the work. The duration, so moral rights are perpetual, as I said, but economic rights have a duration of the life of the author plus 100 years. And this was actually, in cases of co-authorship, those 100 years shall be counted as from the death of the last co-author. And the last extension of the term of protection took place in 2003. It used to be 75 years, but it was extended to 100. Many of the aspects of U.S. law are also adopted in Mexico, like work made for hire. So if you have an employee and this employee creates a work of art, that will belong to the employer as long as you have a contract in place or an employment contract in which you discuss the economic rights that derived from for any work produced by that employee and that would belong to the company. Also, fair use. Fair use is also, it applies in the United States. It also exists in Mexico, and therefore it applies to those cases where you have works of art that you could use for educational purposes, and in those cases you would not necessarily be exploiting the work. There's also the need to display a copyright notice, and I have specified there in the slides the ways that in Mexico that's required. If you fail to display copyright notice of a published work, it could be fined by the National Copyright Institute. Those are the fines that exist in Mexico that appear in the slide. And the copyright protection in copyright infringement lawsuits, where you could also get fines from the National Copyright Institute for the infringer. And you could also even get, punishment by the Mexican Institute of Industrial Property. So there are two different entities, and the INPI, which is the Mexican Institute of Industrial Property, is the one that manages trademark registrations, but it also has participates in what has to do with copyright infringement when it's related with trade, with transactions, and therefore in those cases it can participate.
Viviana, I think we missed what you were saying when you said if you don't put the copyright notice, what happens?
If you don't put the copyright notice and your work has been published, you could be fined by the National Copyright Institute.
Wow.
And then what are the moral rights? Can you give an example?
I'm sorry, I couldn't understand.
Oh, you talked about moral rights as opposed to economic rights.
The question?
Can you hear me?
Oh, I can hear you now. Sorry.
Yeah, what are those moral rights? Could you give us an example?
Moral rights are basically just the right that your name appears as the author of that work. So no matter what, if, for example, there is a song or there's a work of art, an architectural work, the name of the author should always be displayed, regardless of the fact that he will not gain economic benefit from that work anymore. But his name has to be stated, and that should be respected. And moral rights are very linked with data protection today. Because a lot of the times when somebody's name is displayed, well, it is part of your under the Berne Convention authorship. It's something that cannot be transferred to anyone, and it belongs or anything related with that person, personal information on that. That's a different story, but in addition to the authorship.
Anyone else have questions on copyright for anybody?
I have one quick comment with respect to U.S. law. So in the U.S., if there's an if you're employing someone and they're working for you, obviously it's best to have it in the agreement that anything that they do will belong to the corporation, but it's also inherent. However, if you have a subcontractor or a contractor come in, you definitely need a written agreement that they assign all their rights to the copyrighted material to the company or to whoever is hiring them. Otherwise, if you use that product for any other purpose than what you hired that person for, then you are infringing their copyright because they ultimately hold the copyright.
Yeah, and there was a question in the chat window. Is there a fine for lack of notice with copyright in the U.S.?
So no, there is no fine for it. However, if you don't give them notice, they can always say, well, we were not aware of you having a copyright for this material. And as such, instead of getting $15,000 per copyrighted material, you get the $750. So it will affect your potential lawsuits gains.
All right, well, maybe we can move on to trademarks then. Viviana, would you like to get us started? Chris, you could put her slide up.
Yep, I will do that.
Oh, did we lose her?
We might have, well, she's muted, it looks like. Let me try to unmute.
I can't see her anymore.
Looked like she was having a bandwidth issue a little bit. So maybe we go on to maybe someone
Daphne?
else.
Sure, let's
switch to Canada.
And I think I wonder, actually, Chris, in the interest of time, I'm going to ask you to stay on this slide for a minute and then jump to my last slide because there are a few things I want to point out. So this slide talks about the current situation, and the situation will be changing, although not to remove the common law rights. So our Trademarks Act is being amended. The amendments will come into force on June 17. So right now we have a relatively narrow scope of statutory protection with respect to ordinary marks, so words, sounds, designs, distinguishing guises, so for example, containers, and then certification marks. So I've said CAA, which is the Canadian equivalent to the AAA, AAA in the US. We have a declaration of use that's required. Registrations have to be renewed every 15 years, and we have some pretty robust remedial relief, which is also going to stay in place. Chris, if we can just move to the last slide in the deck.
Sure.
Everybody close your eyes. There we go. So here on the left-hand side are some of the changes, and I think these are really important for your companies to be aware of because you can take steps now that are going to save you money. We are going to be changing the way fees are required to maintain registrations. So you're going to have to renew every 10 years as opposed to every 15. And the fees are going to change to a fee per class basis. Right now, the way goods are defined in Canada, we haven't yet or had not yet adopted the Madrid Protocol or the Nice classification of goods. And so you could actually get a very broad single registration with many goods included. This is going to be changing so that we are going to be harmonized now with many other countries in the world. But if you were to today and before the law changes on June 17, pay renewal fees early, then you will be able to take advantage of the current fee structure that is not based on class, because for some of your trademarks, there could be many, many classes that are found within the current registration. And so that will potentially increase significantly if you are renewing marks after June 17. Another consideration is to file your multi-class applications early so that you can take advantage of the current filing fee requirements, because that too is going to be changing. So if there's anything you take away from this call today on trademarks in Canada, it's that June 17 is the transition date, and there are some significant cost savings that you can realize. After June 17, to note, we will no longer require declarations of use. And so that is something that many people will be, I think, happy about because it has been a bit of an impediment. There'll be a broader definition of trademarks, and so non-traditional marks will be included. There was one question that was asked about the fees per class. I don't actually have them exactly at hand, but Chris, maybe what I can do is I can send you that information. And can you make it available to everyone on the call afterwards?
Sure. Yeah, I can do that. On the website, I can add both this video and whatever information you guys want me to link to. So just email that to me.
Okay.
Okay, Viviana, you're back.
Thank you. I'm sorry. I got disconnected and I think you heard me scream. So I'm sorry. Okay.
So we're moving on to trademarks in Mexico now, I think.
Yes, please.
Yeah, here we go. Okay.
All right. So trademarks in Mexico are very similar, have a law, are regulated by law that is very similar to other countries in Latin America. You can register your trademark. You get rights from the moment of registration, not from the moment that you start using the mark, like in the United States. And it has a 10-year duration, the registration. So you have to renew it every 10 years. There have been some amendments to the Mexican IP law, which took place last year in August 2018. It started being effective. And one of the things that the new law brought was that there is a requirement to file a declaration of use before the Mexican Institute of Industrial Property, which is called the INPI. This is required within the first 3 months after 3 years of registration, and you also have to submit a declaration of use at the time of renewal. The difference with the United States is that you do not need to submit evidence of use. You just simply need to make a declaration of use under oath. And if you fail to do that, the trademark office could not renew your mark and also not necessarily grant registration not grant registration, but it could cancel the mark if it has not been filed within the first 3 months after 3 years. The other particularity of Mexico is that it did not have opposition proceedings. Third parties could not oppose to the registration of a mark under the registration system with a time frame to oppose and a time frame to submit evidence and a reply. But this changed, and now they have the possibility of having opposition proceedings. What happened before was simply that you could raise your objection to the registration of the mark, and it would be something informal. You would submit some document to the trademark office, but today they do have an opposition proceedings adopted. Mexico is one of the few countries in Latin America that are members of the Madrid Protocol. Colombia, Cuba, and Mexico are the only countries in Latin America that are members. It's a great benefit for many people who want to file one application for multiple jurisdictions, in which each trademark office will review the matter, and then you will get one international registration in the end. So Mexico is one of these countries. One of the things that have occurred lately is that you can register a sound, a smell, and hologram as trademarks. And they have also regulated secondary meaning. So if a trademark that is considered descriptive has gained distinctiveness or secondary meaning, it could be registered if you submit evidence of that distinctiveness. Finally, so a trademark application, before there was no basis for refusal based on copyright, but now there is. You could actually claim that you have a copyright, and that should be the basis for refusal of a registration, a trademark registration. There's also a basis for bad faith in order to convince the trademark office that they should refuse registration of a mark, or they should annul a registration that they have already granted. And finally, there's also the possibility, and this works for big corporations who have well-known trademarks or reputable marks. You can submit to the trademark office a declaration of reputation or fame of your trademark, and with very robust evidence, and covering certain goods or services that that trademark identifies. And with that recognition that the trademark office makes, that could be your basis for future oppositions or cases that you have against other trademarks that may be similar to yours. That's in a nutshell some of the highlights of Mexican law.
Yeah, Arash, you ready?
I am. While you're bringing my slide up, Chris, so let me say that trademark generally just protects the symbol, name, words, or design used to represent a product or a service, whereas copyright was the author's actual original work. So those are the two differences between copyright and trademark. Another interesting thing is that trademark can potentially never expire because you can renew it originally it's every between the 5th and the 6th year, and then every 9th between the 9th and the 10th year. So a trademark could potentially go forever. It does require that in the US, we do require a declaration of use. You can file a trademark if you haven't used it yet as an intent to use, and then once start using it, then you have to file that declaration. And once it issues, the declaration of use has to be submitted within 6 months of the allowance. You can get up to 5 extensions, and if each extension is 6 months, so you can delay the use of your trademark for potentially 3 years if you want to. But after 3 years, if you haven't started using it, the United States Patent and Trademark Office will just abandon and cancel your mark because they don't want you to hold on to a mark that you're not using. I think everything else pretty much is the same with respect to the marks in Canada and United States.
I just noticed a chat question came in, and it's what will be the cost per class? I'm guessing maybe this was directed to Daphne since she mentioned that that's changing. I'm sorry I missed that question earlier, but chime in again on the chat if you were asking something else.
Well, if there are no other questions, let's move on to trade secrets. Arash?
Sure. Chris, if you could just bring the next slide up.
Will do. There we go, trade secret, okay.
All right, so trade secret is kind of interesting because while in patents and trademarks and copyrights, you're showing things, in trade secrets, actually you want to prevent other people to see it. So in order to have a trade secret, you need to have something that is not generally known to public. It does bring an economic benefit to your company, and then you have to make efforts to keep it a secret. So you actually should have some sort of policy in your company to say, for example, you're not supposed to take it home, you're supposed to keep it within certain parameters, and so forth. Obviously, if somebody finds out about your trade secret, they can't be infringing your trade secret. So that's called a misappropriation. And in order to, there are two things that it has to be done. First, you committed misappropriation if you personally acquired that trade secret by improper means. There have been cases where they send androids up in the sky and take pictures of the facility where they were making a product. And so they were trying to figure out what the product is or how the product is being manufactured. So that was misappropriation. And then you also are misappropriating if you know that something is a secret and you publish it or give it to somebody else. And there are different remedies for it. Obviously, the injunctive relief is probably the most popular one because if you're keeping it a secret, you don't want it to go around, so you file for injunctive relief so that they don't publish it. And then if you have any damages resulted from the publication of the trade secret, then you can potentially collect the damages. And you can potentially get the attorney fees, but the courts are not as lenient with that with respect to as they are with the copyrights.
Yep. One comment I have just to mention is that if you're not aware of this, there is now a federal cause of action under a relatively new statute in the U.S. So that was enacted in May 2016, and in the old days, you used to have to go under one of the 50 states' laws.
That's right.
So that's a pretty interesting development in the last couple of years, and I think it may be related in some ways to the rise of sort of the big data economy and the increasing importance of trade secrets.
I have a quick question. This is David Shopey. If you said that there is obviously an intent to keep it a secret after a misappropriation, but what if the misappropriation is somewhat public in nature? Isn't the cat out of the bag at that point? And is there a way to put the cat back in the bag with injunctive relief?
No, so once it's out of the bag, it's out of the bag, right? So you can tell them to stop publishing more material, but then you have to go for damages because who knows who has seen that information, right? But you can limit the publication by having the injunctive relief.
Okay, Daphne, want to move on to Canada?
Sure. So,
Let's see. Just let me know which slide to be on, Daphne, because we were jumping
should be
around.
number 3.
Okay.
So, the law in Canada, we do not have a federal statute that generally protects trade secrets. So we are the U.S. what was it, May, Chris, of 2016?
May 2016 was the enactment, I think.
So for the most part, it's protected by common law, unless you fall within one of the categories of certain subject matter, like if you're a new drug or a biologic, then we have specific laws that protect that technology, data protection laws. And given this group, I'm sure you're not at all interested in learning the details about that. So focusing on trade secrets more generally, it's not unlike the US in terms of misappropriation. Your information has to have been kept company confidential. If it's communicated, it has to be communicated in confidence. So you really want to have robust non-disclosure agreements if you're sharing information with other parties. And if you are going to succeed on a remedy, there'd have to be some kind of misuse by the receiving party. And further to David's point, it really is, if the information is publicly disclosed, there is no way to put the cat back in the bag in Canada. And so you really are limited to a monetary remedy. And there's some industries that I think it's more difficult than others in terms of maintaining trade secrets. So in Canada, we have very active oil and gas sector out west. There's lots of movement with employees going from company to company every few years. And there's a real risk of information potentially being lost that way, whereas other industries have less movement, and perhaps it's a little bit easier to maintain company confidentiality. But I think on this side of things, the trade secret law, at least under the common law, I think is quite similar to the US.
Okay, Viviana, what should we know about trade secret law in Mexico? Is it protected similarly?
It is protected, and it is regulated by Mexican law. To be a trade secret, the information must be always making reference to the nature, the characteristics, or the purpose of the product, or to the methods or the processes of production. It can also be the forms of distribution or marketing of products or rendering of the services. But any information that is openly available and is obvious to experts in the field or is required to be disclosed cannot be considered trade secrets. But it pretty much follows the same as the US.
Okay, well, I think we only have about 11 minutes left, so we're going to try to speed up. The next topic on the agenda was patents. Viviana, do you want to start and just hit the high points and anything that you want to make sure that you say before we're done? Now would be the time.
Okay, well, for Mexico, so I have very detailed slides, so, but basically it follows the same as the US. It's pretty standard. Some of the, you have a list there of what can be patentable and what is not considered an invention. One of the highlights of in Mexico is that a lot of times it's very difficult to invalidate patents in Mexico. So you could pursue an invalidation proceeding, but you have to have very good or very robust evidence. And it also takes a while for you to try to invalidate a patent. It can take a good number of years, and a decision, the first decision of review, it could take actually up to 3 years. Some of the, it's a very friendly jurisdiction, so it's pro-patent. Although the government in some cases has tried to show that patents increase the prices of medicines, overall that's the minority of cases, and the government does support patentability, and this works a lot for people or companies that are pharma clients, and that's pretty much it.
Okay. Arash, do you want to go next?
Sure. Chris, if you can bring my slides in. So in the US, there are really 3 categories of patents. One of them is utility patents, the other one is a design patent, and then there are plant patents. For utility patents, you have 2 cases. You can either file a provisional application, which buys you, it's a kind of a placeholder, buys you 12 months to perfect your invention, and then file a non-provisional application. And then the second method is filing the provisional, a non-provisional application from start. And then you have the design patent, which doesn't really have any functionality, but it's the way it looks. It's the ornamental shape of the product that you are patenting. So each of these have different lifetimes. So in the United States, the utility applications have 20 years from the filing date, and that 20 years starts from the previous, if it was in provision, it's from non-provisional application. So if you file a provisional application first and then non-provisional application, the 20 years starts from the non-provisional application. So you gotta get a 1 year free kind of date. The scope of the protection for the design patent, the term of it is 15 years from the issue date instead of 20 years from the filing date. So depending as to how long it takes for it to issue, you may actually be better off with a design patent when it comes to the length of protection. If you want to file the patent in a foreign country for a utility application, you have 12 months to get the priority date of that country. So if you filed in Germany first or Canada, if you file it in the United States within 12 months, then you get the Canadian filing date. But for design patents, that is only good for 6 months instead of 12 months. So in Europe, if you file a design patent and you want to file it in the US, if it's within the 6-month period, then you get the priority date. If you miss that 6 months, then you get a new filing date.
Okay, Daphne.
So much of our law has been harmonized with international standards, so very similar to the US and to Mexico. One distinction, though, is we don't have the same division in the U.S. as in terms of designs. We have our designs are protected under the Industrial Designs Act. For plant patents, we have something called plant breeders' rights. You cannot actually protect a patent, a plant per se, by way of a patent. So that is one difference. We also have a 20-year term, but we don't have any kind of adjustment for delays at the patent office. And Resh didn't mention this, but I think in the US, you'll often see PTO delays adding some period to the end of the 20-year term. In Canada, you don't get that. So the patent office can be as slow as it likes, and you don't have any real way to recover that lost term. our fees are also annual in order to maintain your patent rights. Another point I just wanted to note, and which I think is a pretty big distinction as between Canada and the US, is there's no damages for willful infringement. And so in the US, I think a lot of companies are probably rightly concerned about the risk of treble or 3 times the damages award. In Canada, we don't have that, although you could have a claim for aggravated damages if there's truly egregious conduct. But otherwise, we really have a full suite of remedies. One other big difference, though, to highlight on the enforcement side, and I think Resh has a different slide on this, but is that an interlocutory or interim injunction in a patent case is very low. So if you are in litigation in Canada, the chances of you being able to keep the infringer off the market during the trial is very low, as our courts consider that to be something that you can compensate in damages. So you could actually have a very high damages award at the end of the trial because the infringer may have been selling throughout, and you would have the ability potentially to elect their profits in order to recover. So I think those are some big differences between Canada and the US.
So Arash, you didn't talk about the post-grant
I did not.
procedures.
I did
Do you
not.
want to say something?
Sure. So in the United States, if you want to invalidate a patent without going through the state or federal court system, you can go through the U.S. Patent Board of an Appeal, and there are 3 ways of going about it. Chris, if you bring that slide up, it's my very last one.
Sure. Okay, hang on. I have to stop this one and start the next one. I misclicked. Here we go.
Not a problem.
All right, so here, last slide. There we go. Okay.
Perfect. So the parties that can apply for these different things are different. So if you want to do an inter-party review, it's for any patents, and anyone can request this IPR, and it can be done at any time during the patent enforcement life, so within the 20 years after it issues. However, there are some limitations. The only grounds that you can have is if it's a novelty or a non-obviousness issues, which is 102 and 103. You do have discovery, and you may be able to settle the case with a third party at any time. The ex parte re-examination, that again, any patents can fall under that, and anyone can file for it. And in this case, you can file it anonymously. So if somebody sees a patent that they may be infringing, they don't have to say who they are. They can just file this ex parte re-examination. And this also has to be for lack of novelty or obviousness. There is no discovery, and it's in a sense you're having the patent re-examined by the examiner saying, okay, these are new references that we found. You missed these references. Can you please review it and potentially reject this? The patent owner can further limit the the scope of the claims to overcome it. And then you have the post-grant review. This one, anyone but the patent owner can file for it. Also, you have to show who you are, that is filing this PGR. And any grounds except the lack of mode 112s can be used. So the 101 rejection, if you think it is not a patentable subject matter, you can raise that issue, and there is discovery. And finally, the last one, which became very popular, was the business method proceedings. So this is only for business methods, which deals mainly with 101 rejection, and anyone but the patent owner can file it. It can be anonymous, and it can be filed at any time during the patent enforcement within the 20 years. And also it can be done for the lack of the mode, the 101 rejection. The cost for filing this patent method proceeding is fairly expensive. I want to say for the first claim, it's like $20,000, and every other claim after that, it's $5,000 to $7,000, as I recall. So the cost can be very high. So one thing that people have done is threaten to file this unless if they let them practice it. So they usually settle it within the $30,000 range, just so that they don't have to go through these proceedings, and it will cover the cost of this.
Let me just step in here because we're at 50 minutes, which is the formal length of our program. Although I'm happy to stay to answer some of the questions that came in if the speakers are available to stay for a few extra minutes.
Yeah, that's fine.
Yeah, I wanted to say something.
Okay.
I just wanted to make a clarification because Daphne brought something up about Canada, which also applies to Mexico. And it's the fact that in Mexico, so there's special law for protection of industrial designs. And also there is not one of the things that you cannot patent is plant varieties. It also is separated. So that's a similarity that we have with Canada.
Okay, there was a question. Is there any stance in Canada or Mexico about the ability of a non-disclosure agreement with a termination date to waive a trade secret?
I can't think of a specific case that has addressed that, but if there is a termination date in the non-disclosure agreement and it doesn't address maintaining, beyond that date any information received confidential, I suppose there's a risk that it could be released. So it's really making sure the contract, I guess, encompasses that any information received is returned, that there's an obligation to maintain in confidence anything received, and trying to deal with it contractually to avoid public release of the information after the agreement comes to an end.
So Viviana, you agree?
Yes, absolutely.
Okay, and then Wendy had a question she really wanted to get answered. If you have a European company that wants to launch in the US and there's another company using the same name in a different class, would you recommend changing the name in the US, doing nothing, or contacting any other company, negotiating simultaneous use agreement? Arash?
So if they're in two different businesses, you don't need to have an agreement. You can file for the trademark and can potentially get it. So because they're in two different businesses, they fall under two different international classes. And in the US, two different entities doing two different businesses can use the same name. So the whole purpose behind the trademark is to not create a confusion of the source of the goods or services. So if, let's say, I'm BMW and I'm selling BMW cars, and somebody comes to the US and starts manufacturing medical equipment under the name BMW, well, nobody who's purchasing a car would ever think of the medical device company. They don't think the source of the original medical device is the BMW motor company. So therefore, both can use the name BMW, even though it's the same name. Two different businesses, not a problem. You can file for a trademark in the US, and most likely you'll get it.
Yeah, I always think of Delta Faucets and Delta Airlines. I don't think
That's
there's
right.
a lot of confusion between the two. So
Exactly.
Now,
Good
do you
example.
think if a trademark examiner disagreed with you, and it turned out that they said, yeah, these are similar enough, or that other trademark is so strong, could you even do a simultaneous use agreement without the first trademark holder losing protection?
You can always have an agreement with the other party. That doesn't mean necessarily that the US Patent and Trademark Office will allow you to register your mark, but if you get the permission from the other side to use it, then you can use that mark. There's no law that says you can't use a mark that is already being used if both parties agreed that there's no confusion. The only thing that is really policing the use of the mark is the other party who's originally had the mark or registered the mark.
Wendy, let us know if we didn't answer anything in your question. And there's one more that popped up here.
can I do a quick follow-up to Wendy's, because I've dealt with situations similar to this? One thing I wanted to recommend in most cases, I actually think a U.S. trademark registration is one of the best deals going. They don't cost that much, and there's a lot of affordable firms out there that can do it. So it's a really good deal. You get an incredible value from that nationwide constructive use that you get with a U.S. trademark registration. So I'm sure that we can all think of exceptions, but generally speaking, you do want to register early in the U.S. That's my thoughts on that issue.
Okay, so here's a question. When does the trademark protection actually start in all 3 countries?
So I'll go ahead and start. So in the US, if it issues, it backdates the original filing date. Obviously, if it doesn't issue, then you won't get it. And there is also what is called common law trademark, and that is when you don't register your mark. However, you are still allowed to use that mark within that geographical area. Now, with the use of the internet, it becomes a little more questionable as to what your geographical area is. But you do have that common law right. So you can potentially prevent somebody from registering your mark if you've been using your mark but haven't registered your mark.
I'll go ahead and answer on Mexico. You get protection only from the moment of registration. Therefore, while you file an application to try to get a registration, you just have an expectation at that moment. You have reserved that date in advance of others, but you will only get protection once you get the registration.
So Bibiana, if you then your registration issues and you discover an infringer in Mexico, you could then presumably enjoin them, but you could only get damages from the date of the actual registration. Is that the way it would work?
Yes.
Okay.
Yes, sir.
So in Canada, because of our common law rights, similarly, you could have rights starting, and once you can establish distinctiveness, and there's some other factors you may have to show, I mean, you could sue on those common law rights. In terms of the registration, you would have to have the mark in order to register, and I believe that under the current and new act, you would still have, as in Mexico, it's from the date of registration. Although I would have to double check if there are some remedies that may be available during pendency once you get the registration.
Okay, and then Wendy just asked, could you file trademark protection based on European registration in advance of use in the US?
Can you repeat the question again?
She's asking, could you file, I think in the US, trademark protection based on European registration in advance of use in the US?
Yes, so you can use it if you file it, I think, within the first 6 months of filing it in European country, then you get the priority date of the European mark. However, if you file it after the 6 months, then you get the new filing date.
And there was also sort of a discussion about a lawsuit between Lexus, the car company, and Lexus, the legal services company. And I don't know if there was a question about that, but one thing that called to my mind was we haven't mentioned this, but there is, at least in the U.S., something called tarnishment. So if there's a famous mark in the U.S., even if there's no confusion, if a mark is super famous and some other party does something that might tarnish the reputation of that mark, there could still be an action in the absence of confusion. So that's an example. And I don't recall the Lexus case, but I do know that is one. There is actionable conduct in the absence of confusion if there's one of them's a famous mark. So that could be the case there. Do you recall that case, Arash?
I know there was a Coach case where Coach tried to say that their mark was famous and prevent somebody else in another business to use their mark, but they failed because the standard for showing that their famous mark is extraordinarily high.
It is.
So it's not exactly an easy thing to do.
Yeah, it's got to be something like Coca-Cola or one of these
right.
super. Lexus, the car company, might achieve that possibly. I don't know about Lexus for lawyers because only lawyers know about it.
I remember that case that she's mentioning of the LexisNexis.
So I just pulled up a list of marks that are considered to be famous: Nike, Coca-Cola, Apple, Microsoft, and Pepsi. Those are some examples of it.
Household names, I think, is maybe I'm not making a legal opinion here, but I think that might be a loose definition that would work. Right.
All right, well, thank you so much to our speakers. Thank you for preparing and giving us all this great information, and thank you to all the attendees for coming.
Yeah, sure.
Excellent. Let me say one last thing, because I got this question several times. Will we be putting this information on the website? The answer is yes. So if you go to www.inthehouse.org, not this moment, but probably tomorrow, what I'll do is I'll post the video of this session along with the 3 presentations. And I believe the presentations also have the contact information for the lawyers themselves. If not, I'll put in their contact information so you could direct follow-up questions to them. Okay, thanks a lot. Thank you so much for hosting, Kathy, and Bibiana, and Arash, and Daphne.
Sure.
Thank you for sharing your
My
expertise.
pleasure. Thank you. Thanks,
Right.
everyone.
Thank you.
Bye.
Take care. Bye.
Bye, everybody.
Bye-bye.